The ficus next to the HR desk was fake, just like the empathy in the room. I remember staring at it while some overpaid consultant with perfect veneers spat out a monologue about synergizing lean transformation. Translation: half the floor was getting axed, and the other half was getting gaslit into thinking that was a gift. When he got to me, the HR girl with the glitter pen slid a manila envelope across the table like it was an artisanal grenade. Inside, termination letter, NDA reiteration, and one smugly bolded phrase: you remain bound by your 12-month non-compete enforceable in all jurisdictions. I didn't blink, just nodded like I was being read my Miranda rights. You know that thing where humiliation hits so hard your blood gets cold? That. Don't take this personally, my ex-boss added, like he was giving me closure instead of ulcers. We're just streamlining the org for agility. This is the same man who once printed out my project roadmap, stapled his name to the front, and pitched it to the board like it came to him in a protein shake dream. I carried his mediocrity for 3 fiscal years and 6 failed pivots. He couldn't build a sandwich without help, let alone a business unit. And yet here we were. Me with a cardboard box, him with a smug little speech about the mutual respect of transitions. I didn't give him the satisfaction of a comeback, just collected my stapler, 2 notebooks, the mug that said, "Coffee is my love language," and most importantly, my originals, offer letter, promotion emails, performance reviews, even the printout of my contract with the old company name on the header, because somewhere between the rebrand and the acquisition, they forgot to repaper. And I don't forget a damn thing, especially not loopholes. Before I walked out, HR tried to play warm blanket. We know this is difficult, but the non-compete ensures a clean exit. Think of it like a sabbatical. I wanted to laugh. A sabbatical implies I asked for it. This was a gag order in legal drag designed to keep me poor and obedient while they recycled my workflows under a new title. Hey, before we go any further, quick thing. If you're listening and this hit something in your gut, hit that subscribe button, toss us a like. 97% of you don't, and trust me, our team reads every single one. It helps us keep telling the stories they'd rather stay buried. Back to the funeral march. As I passed the new intern doing TikTok dances in the lobby, I realized something else. The letterhead on my termination memo had the new logo, but my contract? Bound to the entity before the merger. No re-signature, no transfer agreement, just a glossy new name and the assumption I wouldn't notice. I didn't argue. I archived. I got in my car, drove home in silence, and pulled out the folder I kept for emergencies, labeled in Sharpie, "If they get stupid." Inside was every scrap of policy they'd violated, every Slack message that proved they hadn't paid my garden leave, every instance where they blurred restructure with retaliation. I wasn't going to fight them on Twitter or write a cryptic LinkedIn manifesto. I was going to document. Because when someone tries to muzzle you, they better pray your silence isn't strategic. The mortgage hit the same day the gas bill did. Perfect little combo deal from the universe. Congrats on your freedom. Here's $2,418.11 due by Friday, or enjoy camping in your own living room. I stared at the overdue notice while spooning peanut butter out of the jar like it was a coping mechanism. No paycheck, no severance, no garden leave. Just the echo of that HR glitter pen voice telling me to enjoy my sabbatical. My sister texted, "We've got you," like she wasn't already juggling 3 kids, a husband who thinks laundry is theoretical, and her own job from hell. I didn't respond right away. I couldn't. Pride's a funny thing. It'll starve before it begs. And even when I finally wrote back, "Thanks," I hated how small the word felt. I wasn't raised to be anyone's burden. I was raised to carry my weight and then some. Quietly, effectively, invisibly, like a damn HVAC system. Recruiters kept calling. Some were genuine, some were clearly feeding off LinkedIn blood trails, asking, "Are you allowed to interview?" With that oily tone that made it sound like they were afraid my ex-boss might pop out of a bush mid-call and slap a lawsuit on them. I stayed vague, didn't mention clients, didn't hint at vendors. Just smiled, answered clean, and waited for them to flinch. One asked, point blank, "You're not breaching your non-compete by talking to us, right?" I could practically hear the lawyer in his pocket whispering through his earpiece. That's when I knew. Even though I hadn't taken a single client, hadn't pitched a single service, and hadn't even updated my job status online, word was spreading. Someone over there was nervous, and nervous men make sloppy choices. Then it came. A cease and desist letter. Certified mail, signature required. Accused me of positioning myself in a competitive capacity by applying for jobs in my field. No proof, no client poaching, just the audacity of breathing professionally. They even cited a lunch meeting I had with an ex-coworker, someone who now worked in HR for a logistics firm, and who invited me out because she wanted to vent. Apparently, that counted as indirect market interference. But here's where it got fun. That non-compete was signed 6 weeks after I started. No new role, no bonus, no additional consideration. Just a Friday afternoon ambush where legal said, "We're updating files, sign this or we'll have to reconsider your place here." I signed. Quietly. Then took it home and stuck it in the folder. Because a contract signed under threat, without added value, is a pretty wrapper over legal mulch. I reread the clause until my eyes burned. They'd lumped in non-solicit, non-disparagement, and non-compete into one bloated paragraph like it was a BuzzFeed listicle for corporate cowards. Sloppy. And in most states, sloppiness like that doesn't hold up, especially not when you fire someone without cause and forget to keep paying them while trying to gag their livelihood. I didn't scream, I didn't post, I didn't even reply to their letter. I just added it to the folder and opened a browser tab, searched. Declaratory judgment, non-compete, terminated without cause, no garden leave. Then I did something they never expected. I made an appointment with a quiet, unremarkable attorney whose reviews all said the same thing. She doesn't talk, she wins. Because now it wasn't just about the job. It was about the principle, about not letting some buzzword-choked VP who signs his name on my blood and sweat tell me I can't exist in the world unless he permits it, and about proving, slowly, thoroughly, and in court, that what they called silence was really just my way of loading the first shell. Her office didn't have degrees on the wall, just a worn leather chair, a coffee maker that sounded like a dying lawnmower, and a stack of folders so tall I started alphabetizing them with my eyes while I talked. I handed over my folder like it was a confession. Offer letter, the updated non-compete, pay stubs, garden leave clause highlighted in neon. She skimmed fast but methodical, the way a good tailor checks seams before hemming the suit. Then she looked up and said the best thing I'd heard in weeks. "They're bluffing. Let's file." No theatrics, no Twitter thread with hashtags about resilience, just a one-line summary in a motion that read like dry toast but hit like a pipe wrench. Petitioner seeks declaratory judgment invalidating non-compete on grounds of wrongful termination, lack of consideration, and failure to honor garden leave obligations. That was it. No emojis, no fluff, just a docket number that said, "Game on." I went home that night and didn't sleep, not out of fear, though that still buzzed under my ribs like a second heartbeat, but out of a weird, bitter clarity. It felt like balancing on the edge of something sharp, knowing I could fall either way but refusing to step back. They wanted me to vanish quietly, maybe take up candle making or yoga until the gag expired. Instead, I chose a courthouse where evidence speaks louder than ego, and the only thing that matters is what you can prove on paper. They responded fast. Their counsel, an old-school litigator who probably wore cufflinks with NDAs etched on them, filed an affidavit calling me a former indispensable strategic asset turned professional threat to company integrity. That line nearly made me choke on my tea. First, I'm indispensable. Then I'm dangerous. Either way, I'm apparently unforgettable. And thank God their arrogance kept the receipts. Because that affidavit? Gold. It admitted I was terminated as part of a budgetary reorganization, which shredded their whole with cause narrative like cheap tissue. And tucked right in the middle was a date, termination effective March 1st. But I had a pay stub that ended February 28th. No continuation, no garden leave, just a cutoff. That alone would have sunk them in most courts. The judge wouldn't even need to squint. What killed me most was how hard they tried to sound rational while leaking insecurity from every word. They threw around phrases like potential exposure to proprietary knowledge and risk to goodwill. But I hadn't shared a damn thing, hadn't emailed a client, hadn't forwarded a file. I was cleaner than their Slack channels. What scared them wasn't what I did, it was what I knew. How much of their ops I built with my own hands while they were busy playing buzzword Jenga. I met my attorney again before the first hearing. She wore the same faded blazer, sipped the same burnt coffee, and handed me a single sheet, our exhibit list. 17 documents, tabbed and timestamped, including the garden leave policy I was never paid under, including the termination memo on their shiny new letterhead with a logo tied to the wrong entity, including the pay stubs that ended just shy of the date they said they'd honored all contractual obligations. I sat there with my jittery hands clamped tight in my lap and my voice steady as stone. Because this wasn't just a job, it was dignity. It was the right to rebuild my life without asking permission from the man who once rewrote my strategy plan in Comic Sans and called it leadership. It was the decision to let the facts speak for me, one tabbed exhibit at a time. I laid it all out on my living room floor like I was about to summon a demon, or worse, a corporate audit. Contracts on one end, HR memos on the other, a rainbow of highlighters in between. I wasn't building a legal case. I was building a murder scene, and the weapon was paperwork. Date of contract, August 2nd. Date of acquisition close, September 9th. But somehow, the new logo, the one from the entity that didn't legally own me yet, showed up on internal emails dated August 17th. Oops. I had emails from marketing announcing the rebrand 2 weeks before the legal acquisition was finalized. Announcements signed off by executives using their shiny new titles that didn't legally exist at the time. And if they weren't the proper entity, they couldn't enforce jack. The contract I signed was with the old company, under the old tax ID. No assignment clause, no consent from me. Just a quiet switcheroo they thought I wouldn't catch because most people don't compare footers to filing dates. They forgot I built their onboarding tracker. I remembered how they buried policy updates under Friday Wins emails so no one would read them. I remembered how they changed the name of our org in the HR portal before anyone signed transition paperwork. Sloppy. My attorney called it assignment gap. I called it a gift. Every contradiction got its own post-it. Green for dates that didn't line up, orange for policy violations, pink for quotes that made them look like narcissists with MBAs, and red was reserved for the things I knew would burn, like the CEO's email bragging about leaning out senior staff to make us look acquisition-friendly to shareholders, sent 3 days before I was terminated, with my name bolded in the attached spreadsheet. Subject line, trimming fat. I submitted a subpoena for payroll records, specifically garden leave disbursements for terminated staff in the past 12 months. My lawyer warned me not to get my hopes up, but I already knew. When the reply came back, I didn't smile. I just stapled the printout and tabbed it. Exhibit 12, zero balance. Not one person, not one, had been paid the required garden leave. The policy existed, but enforcement didn't. It was a phantom clause, pretty on paper and useless in reality. Until now. That's when the paper trail stopped being a defensive measure and started becoming a weapon. Because now I had a pattern, a timeline, proof that they weren't just careless, they were calculated. They knew the contract was flawed, they knew the garden leave policy was ignored, they knew the entity shift gutted their leverage, but instead of owning it, they bet on silence. They thought I'd stay quiet, scared, desperate for a LinkedIn badge that said open to work. Instead, I handed my lawyer a binder thicker than their employee handbook. She flipped through it and murmured, "This is tight." Then under her breath, almost like a joke, "They won't know what hit them." The joy wasn't loud. It didn't feel like triumph. It felt like tying the last knot on a trapdoor and stepping back to let gravity do the rest. I didn't need to scream. I didn't need revenge porn or Slack leaks. I had dates, footers, logos, and a single email from legal that spelled the company name wrong in the signature block. That went under Exhibit 17. Not because it was damning, but because it was delicious. They'd made a show of being professional, and I was about to show them what actual professionalism looks like when it's sharpened into a blade. Their junior associate, some fresh out of law school golden retriever with a name like Connor or Chadwick, emailed my attorney a meet and confer request like he thought we were planning brunch, not a legal dismemberment. The tone was polite, smug, laced with phrases like amicable resolution and maintaining professional reputations. But buried in the footer was the real gift. A company registration number, entity ID 86472B. I blinked, then cross-referenced. My contract? Bound to entity 71290W, the company I agreed to work for, the one that no longer technically existed when they fired me. No signed assignment, no consent, just a silent leap across legal boundaries and the assumption I'd never trace the numbers. But I had. That one auto-populated footer just confirmed everything. They had no jurisdiction to enforce what they were threatening me with. The thrill was instant and ice cold. I didn't grin. I didn't text anyone. I just printed the email, highlighted the footer, and slid it into the binder. Exhibit 21. Right behind the offer letter with the original entity and the termination memo branded with the new logo. The contrast sang like a tuning fork. Their mistake wasn't just clerical, it was fatal. You can't enforce a non-compete if the enforcing party doesn't legally have a relationship with the employee. That requires transfer, consent, something, anything. But their house of buzzwords was built without a foundation, and now the cracks weren't just visible, they were structural. Then came the overreach. Their legal letters, plural, were a linguistic blender of legalese and desperation. One line would scold me for client solicitation. I hadn't contacted a soul. Another for contract interference. With what exactly? Then pivot to accusing me of damaging company morale by circulating misinformation. Misinformation, in this case, meant attending a networking event with a badge that still had my last name on it. The final paragraph demanded I cease and desist all competitive positioning. Competitive positioning. I showed that phrase to my lawyer. She exhaled hard through her nose, which I'd come to learn was her version of laughing. They're trying to roll 3 clauses into one, she said, circling the paragraph. Non-solicit, non-disparagement, and non-compete. That's excessive. Judges hate excessive. Especially when your pay stubs stop before your end date. Especially when your garden leave clause remains a museum exhibit. Especially when the very entity you're claiming harm through doesn't hold the contract. I went back to the binder. Every page was proof, not opinion, not feelings, just cold, orderly evidence of everything they got wrong. Exhibit 3, offer letter, entity 71290W. Exhibit 6, promotion confirmation, same entity. Exhibit 11, pay stub trail, ends February 28th. Exhibit 14, garden leave policy, HR PDF, page 6. Exhibit 15, payroll response, 0 disbursements. Exhibit 17, email with new logo, dated pre-acquisition. Exhibit 21, Connor's auto footer. Entity 86472B, all of it neatly tabbed, color-coded, dated. This wasn't just a paper knife anymore. It was a guillotine. They were trying to fight in the court of vibes. I was building my case in the court of facts. And somewhere in a sleek downtown office, Connor probably hit send and went off to microwave his lunch, thinking he'd done his job. Meanwhile, I stared at his mistake on my screen like it was a constellation finally aligning. I didn't need a mic drop. I had a signature block. The hearing room was colder than I expected. Gray carpet, cheap ergonomic chairs, and one ficus that looked like it hadn't known sunlight since the Bush administration. I sat with my hands folded, binder in front of me, notes tabbed so precisely it would make a librarian weep. My lawyer sat still as stone beside me, but I could feel her anticipation like heat off a radiator. She knew what I knew. We didn't have to perform. We just had to listen. Then he walked in. My ex-boss, Jake. Hair a little thinner than before, but the ego was fully intact. He sat at the witness table with all the gravity of a man who thinks leadership means never shutting up. The clerk swore him in, and he adjusted his cufflinks like the room was about to turn into his personal LinkedIn video. Ms. Reynolds, he began, addressing their counsel, was one of our key assets. High output, high visibility, heavily integrated into client-facing infrastructure. I watched the judge scribble something, probably a bingo card. Jake went on like he was auditioning for a TED Talk no one asked for. We didn't want to lose her, Your Honor, but we were in a transitional optimization phase post-acquisition, strategic reshuffling for sustainability. Translation: we fired the expensive women to make space for cheaper interns. He kept tossing out phrases like organizational realignment and margin recalibration, all while painting me as both critical and replaceable in the same breath. I made a note in the margin. Pick one, Jake. Then came cross-examination. My lawyer stood, adjusted her glasses, and opened with a scalpel. You stated Ms. Reynolds was terminated due to strategic reshuffling. Was this a performance-based decision? Jake hesitated. No, it wasn't about performance. Was it disciplinary? No. Was it with cause? He blinked. No, it was a budget decision. There it was, on the record. Out of his mouth, not cause, budget. which means the non-compete clause, which only holds in cases of misconduct or resignation with consideration, was already starting to wobble on its legs. My lawyer let the silence stretch just long enough. Then she moved in. Can you produce the signed assignment documents transferring Ms. Reynolds' contract from the original entity to the new parent company? Jake looked to their attorney. The attorney looked like someone just handed him a live grenade. I believe that would be with HR, Jake stammered. No record on file? The judge asked, eyes narrowing. I'm not personally aware, Jake muttered. Noted, the judge said, jotting something down. My lawyer turned a page. Can you produce payroll records showing Ms. Reynolds was compensated under the garden leave policy during her restricted period? Another pause. Counsel stood. Objection. This is outside the scope. The judge raised a hand. It goes to enforceability. Overruled. More silence. Counsel turned, whispered something to Jake. He swallowed. To my knowledge, Jake said, no garden leave payments were made. The judge nodded slowly, like she was watching dominoes fall. So, terminated for budget reasons, no assignment documentation, no garden leave. Jake nodded, unaware he'd just narrated his own burial. I sat still, didn't blink, didn't move, but inside it felt like watching a man step confidently into a puddle without realizing it was a sinkhole. He thought the room would believe him because he spoke with authority, but authority without evidence is just noise. The judge turned to our side. Counsel, please prepare your exhibits for review. We handed over the binder, tabs already aligned, every receipt, every inconsistency, every date-stamped contradiction. The judge flipped to Exhibit 17, the termination memo, new logo, wrong entity. She tapped the top of the page with her pen. Mr. Carlson, she said, calm as ice. This logo, when was this adopted by the organization? Jake fumbled. Mid-August? And the acquisition closed? September 9th. The judge didn't smile, just turned to their counsel and said, you'll need to explain the basis of enforcement under an entity not party to the agreement. In that moment, the room shifted. You could feel it, the way air changes right before a thunderstorm. The energy snapped from confident to cornered, from aggressive to scrambling. I didn't gloat. I just turned the page in my notes, because they'd talked themselves into a corner, and I'd drawn them a map with only one way out. The judge didn't raise her voice. She didn't have to. That's the thing about power when it's real. It doesn't perform. It just lands. She tapped her pen on my termination memo like it owed her money, then said evenly, let the record reflect that the memo is issued under the branding of Entity 86472B. The contract in question references Entity 71290W. No assignment clause, no addendum, no consent, different party. I sat perfectly still, hands folded in my lap, breathing through my nose like I was holding back a scream, not of rage, but of pure vindication. I'd waited months for this moment, documented everything, bit my tongue until it bled, said nothing while they threatened, cornered, and postured. And now, the room was starting to tilt. She turned a page. Section 48.12 of the Labor Code is clear. A non-compete is only enforceable when an employee departs voluntarily or is terminated with cause and receives consideration in the form of continued compensation, commonly referred to as garden leave. Her eyes moved to Jake like he was a student who hadn't done the reading. By your own testimony, Ms. Reynolds was terminated for budgetary reasons, therefore, without cause. No garden leave was issued. No contractual reassignment occurred. In such a case, the non-compete lacks enforceability. Jake didn't speak. Opposing counsel leaned in and whispered something, probably, don't say a word. Their junior associate, the one who'd been nodding smugly for the past hour, went still, hands tucked under the table, like maybe if he made himself small enough, he could vanish. The judge looked back at us. Ms. Reynolds, your materials have been... She paused, flipping another tab. Exhaustively thorough. I see no evidence of client solicitation, proprietary disclosure, or disparagement. The cease and desist appears to have been sent based on speculative harm, not demonstrated breach. My attorney nodded once. I didn't move. I wasn't giving them anything. Not a grin, not a twitch, not a single ounce of satisfaction. The judge capped her pen. Unless compelling new evidence is presented, I see no legal basis to restrict Ms. Reynolds from pursuing employment in her field. "Counsel," she said, turning to their side, "I suggest you consider alternative resolutions before we proceed to judgment." That was the moment. You could feel it break. The fragile wall of confidence Jake had walked in with cracked from the inside. He turned to his attorney, voice low but still audible, and muttered, "What the hell does she mean, alternative resolution?" His lawyer didn't answer right away, just scribbled something on a legal pad and slid it across the table. I couldn't see the words, but I knew what they were. Something close to, "You're bleeding out. Stop swinging." Meanwhile, the judge was already rising. "We'll take a recess. I expect to return with clarity." We stood. I gathered my binder like it was sacred text, and for the first time since this started, I allowed myself a breath deeper than my chest. Not a victory lap, not yet, but the kind of breath you take when the current starts pulling the other way. Jake avoided my eyes. The junior associate kept staring at the table. I didn't need to say a thing. The law had spoken, and it spoke in footers, policy clauses, and the number 0 printed on a payroll subpoena. The recess room had bad coffee and worse chairs, but I barely noticed. I sat with my hands in my lap, elbows tight to my ribs, binder unopened for the first time that day. I didn't need to flip any more pages. They were flipping theirs. Across the hall, the door to the opposing counsel's room opened just long enough for me to see Jake pacing, face red and movement sharp, like a man realizing the lifeboat he built leaks at both ends. The junior associate was nowhere to be seen, probably sent to go find coffee and never return. Then came the note, slid across our table by a paralegal who looked like she wanted to be anywhere else. 2 words, handwritten in tight block letters, "Settle, now." My lawyer read it, exhaled like a sniper releasing the trigger, and leaned over to me. "They're coming around, don't flinch." I didn't. 15 minutes later, their counsel returned with the fakest calm I'd ever seen, voice syrup thick with faux diplomacy. "We'd like to propose a resolution to avoid prolonging proceedings." Of course you would. The offer came quick. Immediate tear-up of the non-compete agreement, full reimbursement of my legal fees, a formal clarification circulated to all staff and partner firms that I am not under restriction of any kind, and a commitment to provide a neutral reference upon inquiry. Jake sat beside his lawyer, lips tight, eyes dead. He looked like he was trying to mentally bill this as a business expense rather than an ego death. I nodded as they spoke, not because I agreed, but because I was counting everything they left out. When they finished, I closed the binder, finally. Then I said quietly, "One more clause." Their lawyer tensed. "What kind of clause?" "Liquidated damages," I replied. "If anyone at your firm, or acting on behalf of it, represents that I'm restricted in any professional capacity again, you'll owe me a fixed penalty per incident. Standard sum. Index adjusted. No room for interpretation." Jake started to speak. His lawyer stopped him with a look. After a pause, he asked, "How much per incident?" I named the figure. Enough to make it sting, not enough to make it negotiable. My lawyer slid the draft language across the table. It was already typed up. She'd prepared it 3 weeks ago. She knew how this was going to end. They read it, they nodded, they signed. And just like that, the threat that had hovered over my career like a bad cloud for 4 months evaporated into a PDF with signatures at the bottom and a clerk ready to stamp it. We shook hands, ceremonial, not cordial, and I walked out with my spine straight, my breath easy, and the minute order already scheduled to hit the docket by Monday. They had come in swinging with contracts, threats, and bravado. They left bleeding words and writing checks. And me, I didn't smile, didn't smirk, didn't look back. Because this wasn't a win to celebrate. This was a fire I'd walked through without screaming, and now the only thing left was to build something new, on ground I knew was mine. The court clerk stamped the order with a mechanical thud that sounded louder than it should have. It echoed, final and clean, like the end of a sentence someone else had been dragging out too long. Judgment recorded, declaratory relief granted, settlement terms confirmed, and enforcement of the non-compete nullified under 448-112. That little line, so dry, so clinical, now lived in public record with my name beside it. Not angry, not bitter, just permanent. I didn't post about it, no triumphant LinkedIn saga, no cryptic Instagram caption with a gavel emoji. Just went home, took the signed court order, slid it into a frame, and hung it above my desk, next to the outlet. Close enough that I could glance at it every time I plugged something in. Not to gloat, just to remember, documentation is armor, process is war, and silence is not surrender, it's sharpening the knife. 2 weeks later, I started a new job. A small ops team, tight knit, no fake plants or performance art management. The CEO wore the same pair of boots every day and ran her own staff onboarding. During paperwork, HR paused over my rider, custom clause, right under salary. A clean one-liner. Employees shall not be subject to any non-compete nor be asked to sign one as a condition of continued employment. The HR manager, maybe late 20s, bright-eyed and good at her job, raised her eyebrows and said, "Smart?" I just nodded. She didn't ask why. She didn't need to. They'd already run my background, seen the court file, maybe even read the case summary that's now being passed around quiet HR forums and legal groups as a cautionary tale. Don't enforce what you can't defend. Don't bluff when the receipts are color-coded. I settled into the new role without a single bump. Nobody called to warn them I was a risk. Nobody whispered about restrictions. If they did, the clause made it irrelevant. One line, no wiggle, liquidated damages looming like a tripwire. Jake hasn't emailed. His company never reached out again. The silence on their end is loud in its own way, like they're hoping I'll forget, hoping this will fade into one more HR footnote. But I don't forget. I frame things. And the next time some exec tries to puff their chest and talk about protecting company assets, they'll be up against precedent, not opinion, a minute order, a case file, a name that won't vanish quietly because someone assumed fear would outlast truth. I don't need revenge. I don't need applause. What I needed was ground that wouldn't shift beneath me every time a man with a title decided I was disposable. And now I have it. They mistook my silence for surrender. It was aim.